Put you over there. Put me over there. Yeah.
Okay, you guys, so welcome to the 2019 contract changes class. How many of you have actually already taken this class? We've got one overachiever. Anybody online who has already sat in on one of these classes that is doing this a second time around?
Yes, I've taken it also.
Okay, so Tony. All right, we got Sharon and Tony.
Yes, and Larry figured out how to get the video on.
Yes.
Yay!
Yay.
Okay, awesome. So back in 2015, the forms committee decided that they were no longer going to implement new contract forms every year. It was a burden for us to learn the new forms, and by the time we got accustomed to them, they were introducing a new form for us to learn. So they decided in 2015 that they were only going to introduce new forms and changes to the contract to buy and sell if they found a compelling reason to do so. So in 2015, they put in the 2016 forms, which became effective January 1st, which is the contract we've been using today. So 2016, we didn't have changes, 2017, and this year we didn't have anything. So they've taken 3 years worth of notes and put together what they feel buyers, sellers, and agents are going to benefit from. Now, a lot of the changes we're going to go over today are because of a low inventory, high demand market. So it'll be interesting to see how long these changes stick around as the market starts to normalize and stabilize. So with that being said, you guys should have 2 different documents in front of you. One is the 19-page contract to buy and sell, and the other is the personal property agreement, which is a brand new form. So if you turn to page 2 of the contract to buy and sell, and as you guys have questions, please chime in, please ask. I do want to create some dialogue, and there will be some sections in here that you'll definitely have questions on, and we'll have some conversation about, and maybe try and put some real world references to them so you can really grasp the changes. So at the top of page 2, in red, you're going to see a whole new sentence. And it says, if this box is checked, buyer and seller have concurrently, and concurrently means at the same time, entered into a separate agreement for additional personal property outside of this transaction. So the reason why they added this in is we're having a lot of sellers that are wanting to sell off their furnishings. And so you're putting that into other inclusions, section 2.5.4, which is at the bottom of page 1. And so oftentimes the lender is saying, hey, we can't have the fire pit and the outdoor patio furniture and the living room armoire listed in this contract. So they added in this new section, which it's not like you're hiding anything from the lender. It's just now going to be a separate document. So if you're still exchanging, are you missing a page?
Yeah.
Do you not have page 2?
No. Oh wait, are they front back?
They're front back.
Never mind.
Yeah. So if you're still doing just your average everyday appliances, refrigerator, washer, dryer, stove, microwave, you're going to write those in other inclusions. That's going to stay the same on the contract. You're not drafting this whole new personal property addendum for appliances. This is only going to be things above and beyond your standard inclusions. So we're talking furniture. Pool tables, yes, would be on that as well. So there's a couple hiccups with this form and a couple things I want to bring to your attention. The only reason you will utilize this form in all reality is if it's going to help you get your file through underwriting. Because if you can write in furniture provisions, pool tables, appliances in your other inclusion section and not even use this form, do it. I'm going to tell you to avoid this form if you possibly can. So the only reasons you're going to use it is if it's going to help the underwriter get the file through underwriting, and that's it. Yes.
So how are you not always going to know that like up front when you're okay?
You won't. So you're going to want to talk to the lenders in advance before you're drafting your offer. And if you're utilizing a lender that you work with on a regular basis, you're going to kind of know what their protocol is. So the reason that attorneys aren't necessarily liking this form is for a few different reasons. If you look at number 7 on this form, there is a box to mark whether or what, if there is or is not a condition to do a UCC search. So a UCC search on personal property, that's when a lender has an interest in the property. So they can have a lien against personal property. It's usually in businesses. We don't see it a lot in residential, but sometimes equipment, office furniture, things like that. So there's a couple gaps in this document in the sense that most people don't know what a UCC search is. It doesn't say who's going to pay for it. It doesn't say what happens if the buyer doesn't like the results. So it's kind of opening a can of worms into things that you guys aren't used to doing and performing. So if you're going to use this form, you need to have a system as to how you're going to handle number 7. So the other thing that's a little bit interesting with this form is number 10, termination. Upon termination of the real estate contract, this PPA, personal property agreement, also terminates. Most of the time in our contract to buy and sell, there is a symmetrical default provision. So if this happens, this happens. If this happens, this happens. So this is just stating that if the real estate contract terminates, this terminates. What if this terminates? Does the real estate contract terminate? What if the buyer says, I've decided I don't want to buy that personal property? Or what if the seller doesn't leave it behind and you go and do your walkthrough? Is that now saying that the seller has violated the contract, that they haven't fulfilled their obligation? There's nothing in here that states what happens if.
Couldn't we just do an amendment to remove it?
You could do an amend, extend to remove it. Yep, and that's a good solution.
Okay.
If everybody agrees.
Right, yeah.
But it's, what if there's a conflict and somebody wants to get out due to this? Can they get out?
Can they get out?
Was the contract breached by the seller because they walked away with something?
This is the,
The answer to that is,
I wrote on here after taking a class from an attorney, when in doubt, do not use this form. Avoid it at all costs.
And that was our attorney that represents our company. So, John Goodman, so.
goodness.
Yeah.
Well, this is the 3rd time I'm kicking it. The other 2 times, that part never came up yet.
Yeah.
So, but you explained this whole paragraph so much better than in the other 2 classes. One of them, it took an hour to get off.
Oh, no. Oh, my
If it's an hour, we're in
God.
trouble.
We're in trouble.
We're having to get
The class I took, they basically said, ask your broker.
Yeah, exactly. So as your brokers, we're telling you this is not the most favorable form. Continue doing what you guys are currently doing, writing appliances into the contract under section 2.5.4. And if there's any furniture or personal property that needs to be exchanged, do it via bill of sale at the time of closing like you have been. The other interesting item for this particular document is if you flip it over, or for you guys on Zoom, you don't have to flip it, but for us here in class, flip it over, number 11. So how many times do you go to home inspection and on the kitchen counter is a note from the seller that says, hey, we're going to be selling the dining room table, we're going to be selling the family room furniture. If there's anything that you'd like to buy, these are the prices, let us know. And the buyer says, yeah, I'd like to buy this, I'd like to buy that, I'd like to buy this. You've already executed the contract to buy and sell. You're at the home inspection stage. This document says on here, this proposal expires unless accepted in writing prior to the expiration of the real estate contract's acceptance deadline. If there's a counter proposal, prior to the expiration of the counter proposal. So you can't even use this form after the fact. And most of the time, furniture exchange is going to occur after the fact. So if for some reason you know going into the property that they're going to be selling everything in the house and it's an estate sale or something, you could utilize this form, but anytime after the fact, it's no good. So it's interesting that they brought this one in. You know, the jury's out on whether it's going to be helpful, but our opinion is we don't see a whole lot of use for it. Any question from our Zoomers?
Not so far.
Okay.
Has anyone joined that has not received the link for the paperwork? It looked like some people are joining, I can't tell.
I think Sunny Fark might have just come on. Sunny, do you have the link to download the documents we're referencing?
We can't hear you, but if you can hear us, you can go to the Facebook page, our company Facebook page, and we put a link on there and you can download it.
All right, perfect. So moving on, now that we're not going to be using the personal property addendum, I want everybody to fold that up, and I want you to tear it up. Let's all do it. Fold it up. Tear it up. Don't you? Okay.
Yeah, if it's given to you, then.
We're not always defined.
That's a good point, and that was actually not an angle that I had thought of. Remember it, if they're putting in things like appliances, that can be put in the contract. There's no reason to put them in there.
Call their lender.
So, yeah, do some due diligence with the lenders. That's a really good point.
I don't want to say that if you get this, then you have to counter. My broker said don't
No.
know what the risks could be, and if they are little things that could easily be put into the contract, roll the deal up or a bill of sale, talk to the other agent and say, you know what, I think there might be some issues. I don't know if you took the class where they kept saying, we're not sure how it's going to work. We're not sure how it's going to work, but this is what I'm hearing. Maybe we can clean this up. Because yeah, we're not always the ones that get to prepare this.
Yeah, that's a great point.
Because if you do use it, then are you gonna have to use that UCC stuff and all that?
I mean, there is the ability to mark does not, you know, that you aren't going to do a UCC search. So you can, but you don't necessarily have to. So you can mark the box that says that you're not going to do a UCC search. And I mean, no, is someone gonna have a lien on their couch? Probably not. I mean, this is a versatile form used for a lot of different purposes. But you know, office,
Like solar.
Yeah, solar could potentially fall under that category.
That I would want to know. If they, you know what I mean, if they hadn't paid for it.
Yeah, exactly. So the other thing that I want to mention is you guys can't create your own form. So since this personal property addendum does exist, because we're telling you that we don't encourage you to utilize it, you can't draft up your own, leaving out a lot of this language. If a form exists, you have to use it. So you either need to use a bill of sale, use the contract, or use this one. So if another agent sends you a document and says, hey, our broker said we're not supposed to use this, so I've created my own, you're not allowed to use that. It's not a Colorado Commission approved document.
If somebody did own a solar system, then would it have to be on here because that's not typical?
I don't believe so. I mean, a lot of us have been writing solar in our contracts as it is. The lenders don't have issues with solar.
Okay.
The problem with why this form evolved is because lenders don't want to loan on personal property. That's it. They only want to loan on the real estate. But solar, we haven't had issues with. So they only adopted this form for items that we were having issues with, struggling to get through underwriting. But the thing about it is you're not sneaking this past the underwriter. The underwriter is going to look at your contract and see you marked a box that says additional personal property has been negotiated outside this contract, and they're going to say, I want a copy of that. So, I don't know.
Nice idea,
But no,
poorly executed.
yeah, maybe not as useful as they thought it could be.
So if we
So-
check that box, we can still use the bill of sale? Or you're saying if we check this box, we can't use this form?
Then you're utilizing this form, correct. Bill of sale, you don't mark that box.
Okay.
Can you still do a bill of sale instead of that?
Yes. And the other thing is, since they can negotiate personal property mid-transaction, now what do you do to your contract? You have to amend your contract and check this box. So,
You couldn't because it says you can.
right, so
Yeah.
it's just, there's all these
So what
reasons
do you
why
do?
you
Yeah.
shouldn't. Yeah. So hopefully that clarifies something that's a little complex and a little complicated.
Sorry.
Hey, good morning.
Can I do bubble calendars with you guys?
Yes, absolutely.
How many are you?
Yeah, just leave them sitting on the table and we'll bring them in.
Sounds good. Thank you.
Bye.
Bye.
All right, so let's move on to a change that I really like. So a change that I really like that I think is gonna help you guys a lot is just in that very next section down below what we just talked about. So page 2, top of page 2, section 2.5.5. So right now, we currently have 2 boxes in this section that state you can mark use only or ownership of parking facilities. So for example, at a condo complex, if there's a detached garage, a carport, or a parking space, you guys would normally, right now as the contract is structured, have to figure out through the HOA, is that parking space deeded or is it for use only and owned by the HOA? So you're calling title companies, you're calling HOAs, you're calling listing agents. In a low inventory, high demand market, you don't have time to research. You barely have time to get to the property and show it, right? So now they've changed this and they've taken out those check boxes and they've just made a statement that you either have the use or ownership of the following parking space. And it's now up to the buyer to research whether that's acceptable to them. Now you're gonna find the information out in the title commitment, because if it is a deeded parking space, it will come up with its own legal description or it will be attached to the legal description of the property. So you will now have the opportunity for your buyer to object to this item under the title objection deadline. So if they thought they owned the parking spot and it's use only and they find that out via the title commitment, they can object to that item.
Stacy, I have a quick question. When I took the class over at Symmetrical, the guy said that just because a parking space is deeded doesn't necessarily mean that it's owned. And I thought that was an interesting comment. And he said that basically the attorneys cannot agree. Have you heard this?
I have not heard anything about that. I don't
Okay.
know why.
I was shocked when he said it also.
Yeah, if something's deeded, I mean,
I've seen a deed where it says, it's right in the deed that the condo has full use of the space.
okay,
Not that it owns it, it has full use, but it's in the deed stated.
but it's in the deed stating that. Okay,
Well, that's what he was saying, because if you own it, that means, that could mean that you can go out and you can
You can transfer.
dig it up. Well, you could dig it up and put something else on it and stuff like that. So his use of
Or sell it.
a lot different than typically we would think of
Yeah.
owning it.
and of course your covenants would restrict what your
Yeah.
ownership rights are to that. But yeah, I think being able to distinguish whether it's use only or ownership in the deed, typically if it is deeded, it will have a legal description. It will actually have a legal description, and that's how you know the difference. But yeah, Tony, I had not heard that, so that was a good question to bring up. So thank you for your help on that.
I guess if
Anything
it
you
doesn't have a legal description, then it's not
Then it's not,
owned, but I don't care if I own it. I just want to know I get to use it exclusively forever. That's the key.
You know, but a lot of these places, especially downtown, you'll see that people will sell their parking spot or rent it out.
Yes,
You know?
but there'd be more value in one that was deeded that you could transfer separately from the unit itself. There could be more value, yes.
mm-hmm.
But again, the nice thing is, this is Mr. Buyer, you go figure this out. You go dig into this information and attach that. You don't have to physically attach it, but it's attached with the title. So if they're like, I don't like the type of deed that this is or the ownership rights that I have, that's when they would get out.
Mm-hmm. So yeah, the exact wording in the contract, just so you guys are all aware, if exact rights to parking space and storage facilities is a concern to buyer, buyers should investigate. So there you go. I think that's a good change. Now you guys aren't trying to race around and figure out, is it owned, is it not owned? Now I got to do an amended sin because I marked the wrong one. It takes a little bit of the liability off of you guys and does put it on the buyer, but bring it to their attention that if they do have any concerns, you guys are going to really want to hone in on that title commitment and see what it reveals. So good change in my opinion. Questions on that one? All right. So let's jump into one of the most significant changes. There are 3 really significant changes. So we're going to start with my favorites. And on page 3, under your dates and deadline chart, halfway down, you're going to see inspection termination deadline. So this is going to be one of those low inventory, high demand changes. And from the classes I've taken, it's a catch-22 as to if this is something that's even going to impact the contract at all. So right now, or in the past couple of years, we're seeing a lot of buyer offers come in that state, I'm going to be really easy to work with at inspection. I want the right to do an inspection, but if I find something, I'm not going to object. I'm just going to terminate. And so we're doing that a lot. So we're putting in an objection deadline, but no resolution deadline. And that's all we're doing. So now they've added in a termination deadline. So instead of even objecting, because you're not going to ask for the seller to do anything, you now just have a date to terminate. So if it's an investor buyer or another buyer that says, I'm not going to ask for anything, all I want is the ability to terminate if something substantial comes up, now you guys have that new deadline provision to work with. So I think that's helpful for those offers. What's tricky is your normal, average, everyday buyer that says, I want to do an inspection, I'd like to have an objection, I'd like to see what the seller's going to fix, and we'll try and meet in the middle and resolve it. So now you have this termination deadline that nobody really has the intention of using, but you've got it in the contract, so you have to figure out how to utilize it. So what we're learning is that if you're a listing agent, you want that termination deadline to be as soon as possible because you don't want it to linger. If you're a buyer's agent, you want that termination deadline to be pushed out as far as possible. So my recommendation to you guys is match it with your resolution deadline. Because right now your inspection resolution has an automatic termination clause in it anyway. So if you guys don't reach an agreement by 11:59 on the resolution deadline, the contract automatically terminates. So wouldn't it make sense that your termination deadline matches? Now what the Real Estate Commission is wanting to avoid is us having an objection deadline, a resolution deadline, and a termination deadline falling after the resolution deadline. So if you go to section 10.3, which is going to be on page 11, there's a whole new termination paragraph, 10.3.2, and it reads, on or before the inspection termination deadline, notify seller in writing pursuant to 25.1 that this contract is terminated due to any unsatisfactory condition. Inspection termination deadline will be on the earlier of the inspection resolution deadline or the date specified in 3.1 for the inspection termination. So they have pre-formatted language that does not allow you to put the termination date after the resolution date. So when you're writing your offers as a buyer's agent, match your termination and your resolution as the same date.
Could you leave that blank if you're having a resolution?
And see, that's where this is a very unique one, because if you don't have the termination deadline, you still have the opportunity to terminate if you don't reach a resolution. So it's kind of a funky.
Because like in my head, I think, okay, I will use that for someone who's said they won't do a resolution, but on a normal transaction, I would just ignore that date.
Yeah, I don't think there's any harm in matching it to a resolution date.
So maybe I just don't understand the lingo, but will be on the earlier of the inspection resolution. So that sounds like it needs to be before your actual resolution deadline, according to this.
But don't you find it weird to put a termination date before your resolution date? Because why would the buyer and seller want to terminate if they still have the ability to resolve?
Right.
Right. Just makes sense. So yeah, and this was a very controversial discussion in the class that I took from John Goodman, because John Goodman said, make your termination date the same as your objection date. And we all said, why would you object and terminate on the same day?
Yeah, that's you want to see if they're going to do anything.
And his rebuttal to that was, the resolution has a built-in termination anyway.
And that's why you
So-
would do the termination prior to the resolution. I don't even want to talk to you guys or try to resolve anything on terminating. You go past that terminating, now we're into the resolution where you can talk about it or terminate it. So I think it's instead, because what if you talked about it, we agreed to it,
And then you still
and now we have a
terminate.
termination date past that day, I can still terminate after a resolve in my resolution. So that's what they're saying. Terminate it, or you move to the next stage, which is resolve it, and you can either resolve it or terminate. But if you let that terminate further out,
Even after
we
you've
resolved it,
agreed,
we agreed, and now I'm still going to terminate. So that's why it's.
But you can still terminate in the resolution.
But in the resolution, you could.
After the first termination.
But what if
does
you
any of that
agree-
make sense?
Yeah.
It does make sense.
Yeah, it does. So that's why I wrote down, based upon his recommendations, if you're the listing agent, make your objection, make sure that your offer comes in, the buyer's offer comes in with the objection and the termination on the same day. Because you're possibly leaving your seller out there at risk if that termination comes after or on the same day as the resolution. If you're a buyer's agent, you want to push that termination as far as you can, so you make it the same day as your resolution.
Or like
So-
you said, you NA it.
But is
We don't
this,
want to talk about termination, we want to do resolution or objection. You get NA it.
but is this gonna make it really hard for the seller to say, if you're sitting there saying, well, we need to counter and say they have to do this, and then the deal falls apart because of something you can probably avoid anyway? It just seems like it's gonna confuse the buyers and sellers to me, but
Yeah, and I think it's gonna depend on how educated you guys are and how
Yeah.
educated the agent on the other end is. Because if you're saying, hey, I wanna, my sellers, I've educated my sellers on what this termination deadline is, and they would like to see it on this date rather than this date. If you're working with an uneducated realtor on the other end that doesn't get it, it could definitely
be ugly.
be ugly.
So, question.
Yes.
So this came about for people who maybe didn't want to do the objection. They just wanted to-
They just want to terminate.
So are we going to an associate termination deadline or instead of an objection on the same date?
You could. You could, or they can put in, I mean, yeah, you
Yeah.
could.
Fire push it.
You would
That's
see
what I would
NA
want to see
for
as a listing
objection,
agent for an
and you would
investor.
just see a date for
Well, that's
termination.
supposedly what you
So
were thinking.
we can't,
We're not going to play.
we can't hear when someone else talks. So if they can speak louder so we can so we can hear what they're saying and what you're responding to.
Okay, yeah, Tony, so the question was, if you just have a client that doesn't want to object to anything, they're just either gonna take the house as is or they're gonna terminate, do you use the objection deadline or do you put NA in that field? And the answer is yes, you can put NA in the inspection objection field and only have a date in the termination field.
Okay.
Yes, Julie, speak up.
Can you re-clarify what you said with your notes, listing agent? If you're the listing agent, you want it to be like this, and the
Okay.
buyer
The
agent.
objection.
Yes, okay, perfect. So let's take inspection objection and inspection termination. You are the listing agent. You receive an offer. And the offer comes in. You want the inspection objection and inspection termination date to match if you're a listing agent. Because the discussion we just had was if the termination, if you guys resolve the inspection issues, but the termination date is still out there hanging, the buyer can terminate and it leaves your seller
Right.
at risk. So does that make sense? Inspection objection and inspection termination date, the same if you're the listing agent. That's what you want to see. If you're the buyer agent and you're writing the offer for your client, you're going to want to write the offer with your inspection resolution and your inspection termination deadline the same, because you're advocating for your buyer. So you want to give them as much time to negotiate those repairs and terminate if they should choose. Clear? Clear as mud?
No, no mud. We want this
No
clear.
mud. We want this clear. So is everybody understanding the concept? Okay, and if you've got an investor that's not going to object, you're just putting in a termination deadline.
As a buyer agent, which two did you say you wanted to have match?
You want termination and resolution to match.
Okay, so then on the listing agent.
You want objection and
That's
termination.
what I'm doing wrong. Okay.
Yep, objection and termination to match. Yeah, that'll be a real fun one for me to try and figure out how to draft in my sample contracts for you guys.
Everyone else on the page just on that.
Exactly.
You said that if you're the buyer's agent, what you really want is the inspection termination deadline the same as the resolution deadline, correct?
Correct.
Okay.
Okay, my question is, so I have a listing and I get an offer. Buyer's agent has put NA in the inspection objection deadline.
Okay.
Does that not obligate the buyer to then do an inspection, although the contract says, the provision says they have the sole right or privilege to do one?
So they can still do an inspection.
Yeah.
They don't have to do an inspection if they don't want.
Correct. They can waive it,
They can waive it.
but just because they put NA in there doesn't necessarily mean they waived it.
No, it does not mean that they waived the inspection. It just means they're not going to be submitting the inspection objection form.
Form, right.
Mhm.
You know,
So
and they could just
could-
go right to termination.
So
if
they
have a
could do an
date.
inspection and say, we found the furnace was old. We're not going to ask you to replace it. We're just going to terminate.
Right. But they also don't have to do an inspection
They don't have
if
to
they
do
don't
it.
want to.
They never have to do it.
Yeah, they never have to. They can take it as is according to the provision.
Exactly.
So if they come back and say, we're gonna terminate because the furnace, is old, and then the seller says, no, I'll fix it. So you still write up a resolution, even though there was no objection,
Correct.
formal objection.
Correct. You would write up a resolution. And you could,
I'm sorry. So if they put NA or just leave it blank under inspection objection deadline, the only way to terminate it would be to put a date in the termination deadline, correct? Based on inspection, because they're saying there's no objection deadline.
Well, the resolution.
I'm not sure I understood your question. Could you say that one more time?
Sure. So if they put NA under inspection objection deadline, like Max was saying,
Yep.
or they leave it blank, they don't have a right to come back and have an objection unless they put, correct? I mean,
Yes,
because
correct. They don't have a right to object to anything. They only have the
Okay.
right to terminate. But what Vicky was mentioning is if they say, I'm going to terminate because of the furnace, and the seller says, oh my gosh, let's not kill the deal for the furnace, we'll replace it. Just because they don't have an objection deadline, the seller can elect to do an inspection resolution and all parties can sign and move forward.
okay, I'm confused. How can they terminate based on an inspection if they don't, unless they put in a termination deadline?
Yes, they would have to have a termination deadline.
Okay, got you. All right, sorry.
Yeah, they would terminate on or before the termination deadline.
Okay.
Just for clarification, does anything, we should never have a blank anything, right? We can avoid that?
Yeah, we always
You should
recommend
put
that you put
NA.
in NA or none.
Okay,
Never
A
leave a
blank
blank.
is like an NA,
okay.
but people can fill it in, or
I know.
did you miss it, or, yeah, I don't like
So,
blank.
yeah, NA
I think you've
or none.
overlooked it.
Yeah, and when I review your guys' contracts, if there's a blank, I say, did you intentionally leave that blank? Because sometimes the answer is no, I forgot to fill it in, or it didn't save in CTM when I filled it in. So always put NA or none, just so that you know, the buyers know, everybody knows that you did look at that line and it doesn't apply, or it's not going to be utilized. Good question. All right, you think we got our inspection termination? It's a tricky one. And that's why I wanted to hit it on the front end of the class while you guys are all awake, because this is a hard one. This is definitely a hard one to grasp. One of the more tricky provisions and changes that they made. So, okay, let me look at, let's go to an easy one. So let's go back to page 2. And we now have a heading for seller's disclosures. Everybody find the heading for seller's disclosures. Under it are the subsection seller's property disclosure and lead-based.
Stacey, can we go back real quick to 3.2? it
Yes.
says in there, when Max said something about leaving it blank, I thought 3.2 says if you leave it blank, it makes any corresponding provision deleted. So if you leave it blank, what is it talking about leaving any corresponding provision deleted?
So it means that it deletes it out of the contract. So if you leave the appraisal section blank for a cash transaction, the whole appraisal provision in the contract doesn't exist. It's like you've struck it out and taken it out of the contract.
Okay, so if you leave inspection objection deadline blank, it doesn't take out the termination part. Is that correct?
Correct. It takes out the objection part.
Okay, that's all right. That's okay.
It's its
As long
own
as you
paragraph. It's
put a
its own
date.
subsection. Exactly. So, for example, this is taking us on a slight tangent, but I want to address it. So say you guys have a client that is buying a home in a subdivision and you're convinced that it's Highlands Ranch, it's platted, they're not going to need a survey. So you write NA, or you don't write anything in the survey section. That's as if the survey is being removed completely. But say title learns that they added a storage shed, or they changed the fencing, or they added to the house, and they're requiring a survey in order to insure the property. If you've deleted it out of the contract, how do you negotiate who pays for it, what the results are, if the buyer has termination rights, if the results of the survey don't come back right. So be very, very careful how you use the word NA and if you leave a blank in the contract. Because it can take out something that you don't think you're going to need, but it ends up cropping up as something down the road that you're going to need to go back to.
Sounds like it's best to just put dates in.
It's best to put dates or none. Or none. Because none keeps that paragraph in the contract.
Okay.
No.
Yep. And that's under section 3.2. It outlines that the none provision means that none applies. So the survey doesn't apply. NA means
So if you
it's out of there.
put none and then something happened, then you can come back to it and renegotiate. Okay,
Correct.
good to know.
Yep. It gives you the opportunity to revisit that if you need to.
And would you put anything in additional provisions to say if a survey is needed, required by lender, or do you just check those boxes in that area?
So you can check those boxes in that area. In the contract example that I have online, I've written in if lender requires it, paid for by the buyer. If title requires it, it's paid by the seller.
Okay.
So you can use that.
Where do you write that at?
Let me look. I actually don't know the section number off the top of my head, although I should. So
Is it just additional?
section 9, 9.1.2 on page 10. So 9.1.2, payment of new ILC or new survey. The cost of new ILC or survey will be paid on or before closing by buyer or seller, and it gives you a line. You can, instead of checking seller or buyer, you can write in to be paid by buyer if required by lender, to be paid by seller if required by title.
So you can actually put none in those dates because your buyer does not intend to do a survey, but you actually fill out this section.
Yep.
Good to know.
Yep. And then it just covers your bases. Better to be safe than sorry. Yeah, and even if you accidentally forget to fill out 9.1.1, section 9.1, section 9.1.1, if you at least have 9.1.2 filled out with the wording I just gave you, it stipulates who has to pay for it, and then you guys can figure out who orders it. I mean, that's not the end of the world to say the listing agent's going to order it, the buyer's going to order it, the seller's going to order it. That's fine. But it's where the dispute comes is who's paying for it after the contract's already been negotiated.
Sounds like I might need to counter something. If the buyer's agent doesn't know how to do that.
Mm-hmm. Yep. Yeah.
We love counters. Don't we love counters?
We do.
Does anybody
Sometimes
else
you're
like
doing them
counters?
just to clean up little things like that. Because it does happen. And when you don't specify who's paying for it and the seller says, I am absolutely not paying for this survey, the buyer's lender requires it.
So would
Lending
you
has
check,
nothing to
would
do
you
with
just
me.
go ahead and check the box though, ordering
would.
of the new survey and just say
Yeah.
who's gonna order
I
it?
would, even if you don't need it,
Okay,
keep it in there, mark it. If it doesn't apply, it doesn't hurt you to have it in there.
okay.
Stacy, do you recommend that you always check for a survey or the ILC?
I think an ILC is just fine. Yep, ILC is just fine. It's more information than you generally need. Generally, you only need the new survey if it's an acreage property, and you're gonna have the survey section filled out anyways if you're doing acreage, rural, something out east, something in a brand new subdivision, things like that. All right, so let's come back now. Did that answer your question, Tony? I know we kind of got that and a little more.
No, actually, it did. Very good. Thank you so much.
Yes, you're welcome. Okay, if we don't have any other questions, let's go back to seller's disclosures on page 2 in the contract dates and deadlines. So in red, you're going to see seller's disclosure as the heading. And under seller's disclosure, we have our property disclosure deadline, which has not changed. And we now have something called a lead-based paint disclosure deadline. So the one thing that I wanted to reference on the seller's property disclosure, although that provision has not changed at all, the wording in the contract has. So let's go to section 10.1. And that is going to be on page 10. And previously, and I think this is a really good change, previously the wording was disclosure of latent defects. And they changed the word latent defects, the phrase latent defects, to adverse material facts. Now, when you look up the definition of latent defects, it's a fault that can't be seen. So something that the seller knows that has occurred to the property that you can't visually see when you walk in. So a lot of sellers were saying, hey, if it's something that they can see, I don't have to disclose it. I only have to disclose the things that can't be seen. Now, as real estate agents are held to a much higher standard, so we have to make sure the seller discloses that information. So the contract has now been tightened so that the sellers are held to the same standard we are. Because us realtors were up here with disclosure and sellers were down here. Now we're on an even playing field. So adverse material facts, they have to disclose everything and anything, even if it was fixed 10 years ago and they haven't had an issue with it since. So that's a change in the wording that affects the sellers and how they disclose things. That doesn't affect you guys, because you've always had to disclose everything.
But Stacy, but they changed that property disclosure and it says, does it now? You know, whereas beforehand it said, did it ever?
It
So
does now exist.
yeah, so now do they have to go back in over to the very far right and say it did this, it did? You see what I'm saying?
Yeah, I do. And I know a couple of them say, does it now or has it ever? But some of those they did modify. My advice, and probably Todd's advice, is disclose, disclose, disclose. It doesn't hurt to disclose as much as you can, because last thing you want is something creeping up after the transaction and the seller saying, hey, I knew about it, but I didn't disclose, and now you're fighting over the wording and interpretation. So, yep, I would write in the comments, hey, there was a water leak from the roof 5 years ago. We had it fixed by a qualified licensed roofing contractor, and we've never had an issue since.
Okay. Yeah, they just really screwed that one up, didn't they?
Yeah, and I'm not a huge fan of the seller's property disclosure now anyways, because when you look through it, it looks like it hasn't been completed.
Mm-hmm.
And it's like, did your seller look at every single line? Or did they overlook a line? I mean, you can't tell what they have read and what they haven't read.
They always miss the HOA, that there's an HOA, whether it has a sump pump. Like every single time I'm like, no, it's gotta go back. Yeah.
I had one just last night. Yeah, he didn't do the pets. Called me last night and said, hey, we have a carpet that's and the washing machine, the dryer and the washer are sitting on the carpet, and there's a bunch of scratches. And our inspection is this morning, and that's why I had to leave. Right? And so last night he's asking me, what should I do? And I said, well, I personally believe you should disclose that. Even if because it's going to look like you're trying to hide it. And if an inspector lifts that carpet up and sees it, it's gonna make note of that.
Yep.
So let's redo the seller property disclosure and then extend the date. We're good. And then that way I can lay my head down on the pillow. Next night, so can't they? They're still gonna buy it, most likely not. You know what I mean?
Mhm.
I just don't wanna live with my conscience going, try to hide something. I can't live with that.
Yeah, and then they did add a line, if you look over to the very next page, page 11, they added a line that addresses any adverse material facts that come up during the contract period too. So if there's something that happens from the time you guys go into contract closing, in the event seller discovers an adverse material fact after the date of this contract, seller must timely disclose such adverse fact to buyer. And then the buyer, of course, has the right to terminate based upon the new disclosure on the earlier of closing or 5 days after buyer's receipt of the new disclosure.
Oh, that's good.
So that's a very good change.
Does that mean like if something happens after inspection that the water heater leaks, they have to refill that out?
They fill out a
They
new
can't just,
seller's
the agent
property
can't
disclosure.
just call you and say, oh, this happened. We just want to let you know we're taking care of it, right? They have to actually.
According to the contract, they have to fill out a new disclosure and you have to send that off to them. The way we've been doing it now is, putting it together an email and making a phone call saying, hey, we're going to get it fixed. Just want you to be aware.
Right.
But according to the new language, they are to fill out a new disclosure and the buyer has 5 days to terminate.
So I know that we can't fill out the seller's property disclosure ourselves, but I feel like it would be a good idea to sit down with the buyers and go through line by line so that they're not missing something. No?
The only problem and my hesitation with that is because you're there, they're going to look to you for advice. So how should I fill this out? So I don't know about this. Can you help clarify this?
I asked
Todd says no.
I asked my sellers when they go through it to just put in the comments either no, or if you don't know, just they don't know, kind of making it like the old disclosure, just so that the buyers understand they did go through everything and they can explain it.
Okay.
That's all I do is just say, can you just clarify over there, because the buyers are going to think you didn't fill anything out. So.
Yeah. So does that help answer your question? We don't recommend, I mean, yeah, it would be nice to help guide them through so that they don't miss anything.
Right.
I think you're
Because
doing
most of the time I get SPVs back that's just like, no, I don't know, and like you say, like the water's not filled out, the HOA is not filled out, like for real. So yeah, but I get it.
Yeah.
Well, on that property disclosure, if you have a house that has carpet in it, there's a line there that says, are there any stains on the carpet? So if you have really,
You should be marking yes every time. I mean, who doesn't have
who doesn't have a
stain
stain on the carpet
somewhere?
if you have carpet? And I know that because I had buyers who said they didn't mark that and there were stains on the carpet and it almost held up our closing because they had a big carpet bleach out spot in the basement under a rug. So when you're talking to either your buyers or sellers, I always look for that line. I'm like, okay, did they really look at this? Because that should be marked if they really looked at it.
Yeah. No, I
Has
think
anyone ever had their sellers go back? Like, how do you say that? Like, how would you say, I don't feel like you looked through this enough? Maybe you.
Where my seller did not mark a box, and the buyer came back and said they need to fill this one out.
Yeah, I've had that.
So maybe say a buyer's not going to accept this, or there's a possibility a buyer won't accept this. So reconsider.
setting a good expectation when you send that seller's property disclosure, hey, this is a really long document. Your eyes are going to start to blur. If you can really sit down and take the time to go line by line by line, there's some, questions in there that you want to make sure you don't miss. And then your job as the agent is to go back through like Angie and pick out those ones that get overlooked and go, hey, looks like you forgot to fill out this one about the carpet. Hey, it looks like you forgot to fill out the water disclosure. Hey, but if you can set the stage that it's going to take some time, so don't be doing other things at the same time because it's a pretty intense form and you just need to dedicate 10 minutes to go through line by line by line.
Well, we used to fill out the water disclosure form, like we did the square footage when it was So why can't you fill that out?
You still should fill out the water disclosure form.
But not on their,
Not on the,
if they don't fill out the property disclosure, then it is your requirement to give us a water disclosure.
Okay.
So if it's not on the SPD, then it's your job to fill it out.
okay, so you still have to, okay,
Yeah.
I gotcha.
So on the SPD,
Because it's on
there's
there
a
now.
database. You can ask them and say, who's your water, and click that, and then they just sign it.
I mean, that's fine too. But I'm
Oh,
saying,
yes,
if they
that's-
gave
that's
it,
Is that
what I
what you're
do.
asking?
Yeah,
Yeah, that's
if
what
they
I
gave
do.
it to you, it's already completed and here it is.
No.
and
Yeah,
it's
the
not done,
beginning.
Don't go filling it in. Yeah,
Right,
in the beginning, you bet.
Yeah, because I usually fill that out before I send it to them.
Yeah,
Because I know,
Yeah, it's just
usually
one
I know
less
the
thing
water,
they have to
yeah,
do.
and they're not gonna figure it out.
because they can't figure it out.
No.
No.
Yeah.
It's funny, I'm always like, who do you pay your water bill to?
An HOA is not appropriate.
Yeah.
We want to, the HOA pays somebody, so I do see that. Oh, it's paid by the HOA.
Yeah, but where
Yeah,
does the
but where
water
does it
come
come
from? You gotta know. Yeah, and the only purpose for that is so that the buyer can call if they have concerns with water and know what the fee structure is and know what the availability of water is. And that's really the purpose, is so that they can do their due diligence on, are water rates really high in that neighborhood? Do they have enough water to support the neighborhood? And we all know Roxborough has really high water rates. So that gives the buyer the information readily available so that they can use it. All right, so let's talk about the other item under seller's disclosures, lead-based paint disclosure deadline. I'm so in love with this change. I think you guys will be too. Section 10.10, which is on page 12. All right, so how does lead-based paint disclosure work right now? What do you guys do when you have a buyer that's writing an offer on a house built prior to 1978? What do you do?
I have to turn it in with the offer, and you have to take the sellers and you have to get it from them and then have everybody sign it before
And how are you getting
And
the
I-
lead-based paint right now?
MLS.
MLS, yeah.
Thank you, MLS, for
I know.
requiring it now.
Yeah.
Yes, that is now a requirement to enter the listing, so that's helpful. Prior to that, we had to try and track down the listing agent. And how often did you get that lead-based paint disclosure when you were trying to write an offer frantically on a listing that had 40 showings? And so 50% of the time you'd get it, and the other 50% of the time you wouldn't. So what do?
Fill out your buyer's part and send it and pray.
Which we should never do. You're having your buyers sign a disclosure that the sellers have not completed. So how do your buyers know what the sellers are even disclosing?
And how many times do we really just write the offer without the lead-based paint done? It's done. It's done often.
It's done a lot. So this change was something that NAR lobbied for, and I'm very grateful that they did, because we were trying to get these documents and we're not getting them. And then if you sign a contract,
11 o'clock.
oh,
Good to know we have 1 hour.
it's like hockey. Should we all have like a stand?
Stand out and stretch.
Steve, who's Steve?
Sounded like hey, Steve.
Steve got that.
You know, it's just a picture of me. I did a screen save and well,
So NAR lobbied for this change because we're trying to write these offers and then we're not including the lead-based paint, and then we're retroactively NAR. And then we're retroactively attempting to get these signed, or we sign them after the fact and they're dated post, acceptance of the offer. And you have a voidable contract.
No.
A void contract. So you can have a seller show up at the closing table and say, I'm not closing because we didn't sign lead-based paint before we signed the offer. So this change is going to help a lot. Section 10.10.1. I'm going to read this just because I think it's very important. Unless exempt, if the property includes one or more residential dwellings constructed or a building permit was issued prior to January 1st, 1978 for the benefit of the buyer, seller and all required real estate licensees must sign and deliver to buyer a completed lead-based paint disclosure sales form on or before the lead-based paint disclosure deadline. If buyer does not timely receive the lead-based paint disclosure, buyer may waive The failure to timely receive the lead-based paint disclosure, or buyer may exercise buyer's right to terminate under 25.1 by seller's receipt of buyer's notice to terminate on or before the expiration of the lead-based paint termination deadline. So the beauty of this is you can put in a date that maybe corresponds with the seller's property disclosure, and you no longer have to submit a lead-based paint with your offer. Yay!
That was the silliest thing.
Yes,
Scrambling all the time.
scrambling all the time.
And it just wasn't complied with. That's the biggest thing. It wasn't complied with.
But it's another.
And it's common sense.
It is common sense.
Yeah, it is common
Yes,
sense.
let's get our offer together and now let's look at our disclosures. And now we can decide whether or not we want to get out of the deal. Versus, can I see your disclosure before I would say if I want to put a deal together?
And because
That makes
the thing about it, and I printed out a lead-based paint disclosure, you guys don't have it in your packet, but I have it here. Regardless, on number 7 of the lead-based paint disclosure, it says, buyer acknowledges federal law requires that before a buyer is obligated under any contract to buy and sell real estate, seller shall permit buyer a 10-day period to conduct a risk assessment. So they've already had the ability to object to this even outside of the contract. It's never been a date or deadline or anything like that, but they've always had the ability to object to lead-based paint. So the nice thing about this is you now have a disclosure deadline. The thing that I do anticipate coming down the pike is that they're going to have to find a slight patch for this paragraph because it doesn't have an enforcement clause. If the seller fails to provide, what happens? The buyer has the right to
The buyer
waive,
has a waive or
they can terminate. So, but what if the buyer doesn't want to terminate?
Then they don't have to.
They can waive, but then the listing agent says, I need this for my file. The company says, I need this for my file. So that was the only thing that the attorneys were saying, that there's no enforcement line on here for the federal law requiring the signatures of this form. So. But I like this one. The other addition is you now have a lead-based paint objection deadline, or excuse me, a lead-based paint termination deadline. So on page 3, under the inspection and due diligence subcategory, in red you'll see lead-based paint termination.
And you were saying do that the same as inspection?
So my recommendation on this is because the form itself says that they have 10 days to object, make this deadline 10 days from the contract acceptance. So if you anticipate the buyer is going to sign the offer by a Monday morning, make this date 10 days out.
You just use MEC plus 10.
Or you can do MEC plus 10. Yep. So that is a good revision. I like that one. But now it is going to obligate you guys to educate your buyers a little bit more on lead-based paint, because before, hey, sign this disclosure, but nobody really read that they had the ability to test for it and what that time frame looked like. So now it's going to kind of put a little more weight on your guys' shoulders as far as when you're going through these dates and deadlines, explaining to them what lead-based paint is and their rights as far as termination.
Do you still have to get the brochure to them? Remember, they have to get it or.
So yeah, go ahead. When you send the disclosure over to them, send a lead-based paint pamphlet as well. And for those of you that don't know, the lead-based paint pamphlet is electronically available through CTM. If you're old school and you want the paper ones, you can order them, but use the electronic one in CTM. Good question. All right, any questions on the changes with lead-based paint other than, yay, we don't have to frantically scurry around trying to obtain that. Perfect. All right, so how many of you guys are still using appraisal gap clauses? If the property doesn't appraise for X amount, buyer is willing to bring an additional $3,000 to closing. Anybody using those anymore? No?
Not really.
So another change that came from low market, high demand is a modification to appraisal. So let me take you guys to section 5.2. And this is under the new loan review section, not actually under the appraisal section. But under section 5.2, page 5, there is a provision in red at the bottom of the paragraph that says buyer does not have the right to terminate based on new loan if the objection is based on the appraised value or the lender requirements. So how often were you getting a buyer that submitted an offer that said we're willing to bridge the gap, and then the appraisal comes in low, and then a couple days later you all of a sudden get a notice to terminate and it says loan objection? And you and your sellers are going, we can't see behind the curtain, but it seems kind of odd that they're terminating after the appraisal came in low, even though they said they'd bridge it. So now they've written in language that prohibits the buyer from terminating under loan objection if it's due to the appraised value coming in low.
And how do you prove
And
that?
how do you enforce it?
Yep, that was the big discussion that we had, is how do you prove it? You can't. You can't prove it, but it is in there. So if you want to fight it, you have the right to fight it, but you can't prove it.
Strange sounds coming from there.
I think we might have some strange sounds coming from a Zoomer, so if you aren't speaking, go ahead and mute yourselves. So that's a change I wanted you guys to be aware of. Whether you can enforce it or prove it, that's to be seen.
That's interesting.
Yeah, isn't that an interesting one?
Sometimes, and we're a little reactionary. I mean, it took 3 years to finally get our contract out, and now the market's got to roll out anyway. And so
Right.
all they're going to see is bridging for the
Exactly.
next 10 years.
And that's why I said I have a feeling that we're going to see a revised contract sooner rather than later, because they jumped on all these, things that we were used to putting in our contracts 9 months, a year ago that we're no longer using.
Sometimes the market fixes things that we try to fix ourselves. Just let the market.
Yeah.
I mean, I sat in the rules and regs for the MLS. We talked about coming soons and how do we take care of them? I'm like, it'll take care of itself. And it's just, we're just kind of in this, just let it take, by the time we figure out how to take care of it,
It
So
will
over.
it'll have
auto-corrected.
auto-corrected, and now we've caused a new weird little.
But I do think this is a good thing for you guys to bring value to your buyers when you sit down for a buyer consultation or before you go to write an offer, and they want to do an appraisal gap or they have any concerns with appraisal. Point out the fact that, hey, if the appraised value does come in low, are you sure?
Because it's right here. You
Because
can't
it's right
terminate.
here that you can't terminate. So educating your
It's a good
clients,
discussion.
it's a good, talking point.
Enforcing it might be difficult, but bringing it up and discussing, hey, it's really in here. We can't play games, might be a good discussion point
Mhm.
With the lender as well.
with the lender as
Yeah.
well.
Have you verified they have the gap?
Mhm.
Yeah.
Exactly. So from that perspective, it is a positive. We'll spin it as a positive. All right, so that's it for that one. What else did I want to go to? Lender requirements, section 6.3. Okay, so next page, page 6, lender requirements. So VA, FHA loans, appraiser goes out there, they see that the roof isn't in the best shape or the paint is peeling, and oftentimes they'll say on the appraisal it's subject to these items being fixed. And previously the seller had the right to terminate if they didn't want to make those modifications for the buyer, but the buyer couldn't proceed with the loan without having them done. So they've reworked this language a little bit. And basically, the way it reads is that 3 days following the seller's receipt of the requirements or closing, unless prior to termination, the parties can enter into a written agreement that they'll be fixed, so you can do an amend, extend, or revise your inspection resolution. The lender, you can provide proof to the lender that the requirements have already been addressed, or the buyer can waive the lender requirements. I've always been confused. How can a buyer waive the lender requirements? They can't get their loan without the fixes, so they can't really waive that, to my knowledge.
Yeah.
Has anyone had that done?
No.
Okay.
Never even had
I don't
an
know how-
appraiser.
That won't fly.
Say I had to fix anything.
Oh, you haven't? On an FHA?
Haven't had what?
I've never even had one that said we had to fix anything.
Yeah.
Who's your lender?
I really like them.
Yeah.
She evidently hasn't done an FHA loan in a while.
So yeah, the automatic termination changes in this one is what they did. So the parties can agree, the buyer can waive, the lender requirements can be done. Wait.
Try and waive them.
But yeah, and that's why I wanted to bring this up is because I specifically wanted to ask you guys if anyone has had a buyer successfully waive those requirements.
Well, and if your buyer and seller are reading that, then they're like, well, the buyer could just waive it. Why can't we just move forward, with that writing? I just think it complicates everything.
Stacy, I actually had a buyer years ago do an FHA loan. The FHA came back and said they needed this stuff done. The buyer wanted the house so bad, he says, I'll go in and fix them. And he did. He went in and fixed the paint. He went in and fixed a couple of things. And, the FHA appraiser went back out by the time he needed to get back out, and it was all done.
Okay.
Prior to closing.
Oh my
the
God.
buyer-
Before closing. It was a short sale. Yeah.
So yeah,
yes.
so
Oh, yeah.
They have.
there's definitely liability, but if you have the seller's permission to make improvements to their house, I mean, it doesn't hurt the seller. If the buyer can't close, they now have these new improved, areas of the home. So yeah, that can definitely be one of the options.
I think the good thing about this is that they took out that the seller has the right to terminate, because in those days, if it's been 2 weeks, then maybe the seller has another offer that's $10,000 over, and they would just terminate and not try to work it out with their current. So for a buyer who's already under contract and spent money for appraisal and
tries to give them some
inspections,
more
it gives them a little more leverage.
Right.
Exactly.
Rather than the seller just saying, nope, next.
Not doing
Yeah.
it. I'm going to take that offer that just came in as a backup that's 10,000 higher.
Right.
So kind of another hot market change.
It's kind of hard to read it with all those strikeouts and everything. But what happens if they don't agree? Does it say in here then it terminates if they can't come to agreement?
So it terminates 3 days following the receipt of the lender requirements.
If they can't come
If
to
they
agreement.
can't come to an agreement.
Okay.
Any questions?
What's the certification for expert negotiator? Because I think I'm gonna need it. I need to.
I'm an expert negotiator.
Practice in the trenches.
Send it to you.
Practice
How much
in the
is that
trenches. Yeah.
Expensive.
Okay, so how's everybody doing on water, food? Need a bathroom break? Feel good? Okay, so let's press forward. This one is a little more complex. This is going to be the changes in the title section and how we're now automatically going with a special warranty deed rather than a general warranty deed. So let's go to section 13. Which is page 13. And the change that they made is that the seller, if no other box is checked, is going to provide a good and sufficient special warranty deed to the buyer at closing. However, if the box is checked, the parties agree to use the corresponding deed instead. General warranty, bargain and sale, quitclaim, personal representative. So if you don't mark any of those boxes, your buyer automatically gets a special warranty deed. So an analogy, just to kind of help you guys visualize the difference between special warranty and general warranty, because they're very subtle differences. So the analogy that I've heard that I think worked really well was if you're going to buy a brand new car and you're going to get a bumper to bumper warranty, one warranty has an exclusion of damage to the car from wind and hail. The other warranty has an exclusion of damage to the car for all weather related items. which warranty would you want? The one that only excludes hail and wind, or the one that excludes all weather damage?
All weather.
You want the warranty that excludes all weather damage?
No, the other one.
No.
You want the one that excludes wind and hail.
Specific.
It's very specific as to what the damage is. That's a general warranty deed. It specifically outlines what the exclusions are. A special warranty deed, more of an umbrella. When you're representing your buyers, I recommend you mark general warranty. If you get an offer that doesn't have anything marked, I don't think you need to counter it. But a special warranty deed is only warranting items that occurred during the time that the seller owned the property. They guarantee that the taxes are paid, their loan's going to be paid, there aren't any mechanics liens, there aren't any IRS liens during the time they own the property. General warranty deed warrants all the way back in eternity.
There's going to be controversy about that with contracts because in those classes at Smedra, they were saying everybody do special warranty deed. That it's like now, and it's like with the class, it's like who's ever had any issue come up with it.
Mm-hmm.
So it's like because nothing is coming up with the general warranty deeds, then they're suggesting everybody just do special warranty deeds.
Right.
To me, it's like I'm representing my buyer. That doesn't make sense to do that. You'd still want the highest and best deed. So, but they're teaching it to do the special warranty deed. So I think we're going to have those issues come up at, with contracts with people putting in special.
Well, and the benefit of title insurance
Only wanted special.
is it protects the buyer from everything. It's the seller that's responsible. So if a mechanics lien comes up and you have a special warranty deed, a special warranty deed, the seller has to pay off that mechanics lien. It's their obligation. If you have a special warranty deed and there's a tax lien from 6 years ago from a previous owner that didn't come up in the title search, the title insurance policy covers that. But you don't go to the seller, you go to the title insurance company. So you have to jump through additional hoops, but the buyer is financially protected from that title insurance. So really, does it matter 100%? If there's not a problem, it doesn't matter. If there's a problem, you can't go directly to the seller. You have to go through title insurance, and you hope you have a really good title insurance company that you worked with that's going to cover it.
So I've come across why general warranty is really important. This was back in North Carolina. There's a new subdivision built. All these people have their homes there and what have you. Somebody comes back out and says, my great-great-great-grandmother deeded this whole land to me. So all the people that had their title insurance were covered by attorneys, to be able to fight their right to have their homes there in that land.
Yeah.
And if you didn't, you're out of luck and you had to pay out of pocket for that. So it's not so much, somebody didn't pay a lien or whatever, but we never know who's going to come out of the woodwork and say, I have rights to this, you don't have rights.
Well, that's what really surprised me about them saying everybody should just do special warranty deeds now. It's like, why? So I didn't agree with that.
Not if you're representing a buyer.
No,
Somebody
Vicki, that's a great point. Okay, insurance covers you for damages. But what if you go to court and they prove that you don't own this property? They can't go against the court and say, well, they own it. Somebody comes from 20, 30, 150 years ago and say this was owned by this group, and we go to court and we find out, yep, it's still owned by this. Title insurance isn't going to give you the property back.
They cover your financial
They cover you financially.
loss.
So, and that's dangerous.
God,
And title insurance is not required. What's
with a
that?
buyer that we had a recent situation with a buyer that title discovered that a deceased party was still on title from 3 sales prior.
Oh,
Wow.
And unfortunately, the title company that handled the sale for my buyer and for 3 sales prior was the same.
Oh,
The president of the title company got involved. He was panicked. Now, I don't know what the liability is for trying to clear a deceased, but the deceased was the husband. The wife would not sign the release.
Wow.
Wow.
How they ended up clearing it. They ended up getting it done, but therein lies the risk. Because again, I don't know that any title policy would there have been.
Yeah, I don't know.
I don't know.
The president wouldn't explain to me the risk the title company was at, so I don't know what it was that it was never defined to my buyer or to me as to what the risk was to my buyer. It took him about 60 days after closing to get it cleared, but he got it cleared.
Interesting. Wow. Yeah, and title insurance are companies. Companies do go out of business. Companies do go bankrupt. So an insurance policy is having that seller give you a general warranty. It's an insurance policy. Now that seller might not know what happened 100 years ago, and you still are going to come into an issue even with this deeded information, but at least now you have somebody else on the hook. So more people on the hook, better. It's insurance.
So you want to know who lobbied for this?
It's gotta be title companies.
Yep.
Of course they
Ding,
do.
ding,
Yeah.
ding. Title companies lobbied for this change in their contract. And the reason, and I was not aware of this, when you prepare a general warranty deed, it states that a general warranty deed needs to have all the exceptions legally listed in the deed, which is then recorded and becomes public knowledge. Title companies don't want to share their information. With a special warranty deed, it's for a snapshot in time, so they don't have to research all the way back. With a general warranty deed, they have to research all the way back to the beginning of time for that property, and other title companies will have access to that information. Now, title companies here in Colorado haven't been preparing their general warranty deeds correctly, and we didn't realize as real estate agents that was part of our job of the closing instructions when we pay our $5 Scrivener fee and say we want the deed prepared. We're supposed to look at that deed and see if those exceptions are all outlined, and if not, we're supposed to call the title company out and say, you need to record these on the deed. But title companies don't want to do that because all their research is compromised, and other title companies can then pull up the deed, see all the research that was done by the title plant, and they don't have to redo the research. So they want the special warranty because it doesn't compromise their information as much. So,
Interesting. I didn't know that.
yeah.
Blockchain. Here's a
Yeah.
blockchain reason what we'll have it someday. Is
Yeah.
we can encrypt our information and they won't have it.
Exactly. So there's legislation out there, I guess, that's potentially going to be passed in the next year or so, which could completely change this and what title companies are responsible for. It will be interesting to see if title companies charge more now for general warranty deeds versus special warranty deeds.
I bet they will.
That could
Oh, yeah. They actually have to do something.
Yeah.
Yeah.
So I don't know where I was. It was recently, but somebody was talking about these changes and said that if you need to find out what kind of deed your seller has and then request that. And I don't know why you
be
would
the
do
same
that.
kind of deed.
Because, I mean, obviously a new build, you're only going to get a special. You're not going to get a general warranty from a builder. So I don't know. I don't know where I was to even say why would that even be make sense to me. It doesn't make sense.
I would dispute that one, especially in an estate sale. You have to give a personal representative deed, and the next buyer can't request a personal representative deed because you've got live sellers, and so I mean that would be the one scenario that could easily dispute that.
Right.
But I don't know.
I don't know what. Remember where
warranty deed. Sorry.
Go ahead, Tony.
With the special warranty deed, what type of warranty is there? I mean, I'm sorry, the personal representative deed.
I don't know my deeds that well.
I wish I did.
Okay.
The attorney prepares it.
Yeah.
It doesn't
Right.
come from title.
But
So-
I'm not sure if it just warranties the time in which the previous party owned it, like a special warranty deed. I don't know the answer to that.
Okay.
Yeah, it's definitely not like a general deed.
No, it's
I
not.
believe it's
There's no warranty.
same as if not equal to. Yeah.
Yeah.
To a
I
special.
don't know if they warrant anything.
Yeah, I don't know either. Because the seller's not alive, so they can't warrant.
And it's not the insurance company, it's the attorney that's doing it.
Right.
But you would
We'll look
still
into
have
that.
title
Yeah,
insurance.
we'll get an
Yeah.
answer for that, because I don't know.
I forget. Yeah.
So are you saying, Stacy, we need to read the deed carefully prior to closing
We're supposed to, but then are you acting as an attorney if you say this isn't done right? Is it outside the scope of our knowledge to say what a sufficient general warranty deed should even look like?
Yeah. Well, how would we know that everything was even on?
You don't.
Yeah.
You don't.
And you might get fired by your title rep.
This is true.
And your buyer should be able to object to it then, right?
Yeah.
To inspect.
Yeah. So I say mark general warranty deed just to give your buyers, and you can obviously tell them, hey, this is what a general warranty deed, this is a special warranty deed, which coverage do you want? I have the opportunity to mark a different box. It should be their decision, but I think when you're representing a buyer, having a general warranty deed is probably going to be the route they want to go. Whether you can really make sure the title company prepares that correctly, I think this new legislation is going to change some of that. So
We should have
Conversely-
Spanish Day.
Yeah.
In answer that question.
Yeah, conversely though, representing your seller, and to
mhm.
Jennifer's point, I was given a special warranty deed,
I want
which
you to
means
agree.
I'm a little nervous what happened before beginning of time. All I got was what I know he did. All I know is what I know. I just want to do a special because I don't know what happened prior to me.
Mhm.
So remember who you're representing.
If somebody had a special warranty deed, and now when that property sells, now the next buyer wants a general warranty deed, can you get a general deed after somebody just had a special?
That's
deed?
what I was just
Yeah,
saying.
yeah.
So I'm the seller.
Yes,
I
yeah.
got a special when I bought it, but I'm guaranteeing that thing to the beginning of time because that's what my buyer wants, and I'll do a general. Am I putting myself out there for
Okay.
risk? I didn't even get a general in the beginning. Did I do some good research? Do I know I have a good title? Do I know I have a good title company that's going to research? Yeah,
Be there.
and be there.
Mhm.
But if you're selling a new construction home and they only got special warranty, that may be a conversation.
Exactly. I think that's what you were coming.
Yeah, that's because I
Yeah.
have a
Or
listing
whoever
right
told
now
you that.
that's, they had a special. We haven't gotten an offer yet, but I'm expecting one. So it'll be interesting. Well, I mean, it's still this, so,
Yeah.
I'm sure they'll ask for general, so it's still the.
You can put it in the broker remarks. Sellers
say.
offering a special warranty deed.
Mhm.
I see that a lot.
Can
Okay.
we move on?
Yeah, so next thing I want to point out really quick, to keep us moving through since we only have another 35 minutes. This is an easy one. This isn't going to change most of your lives by any stretch of the imagination. On that same page, next section down 14, payment of liens and encumbrances. So they now have a provision in here that states that the seller, okay, so I'm going to read this. Unless agreed to by buyer in writing, any amounts owed on liens or encumbrances securing a monetary sum, including but not limited to any governmental liens for special improvements installed the date of the buyer's signature hereon, were assessed or not, and previous year's taxes will be paid on or before closing by the seller from the proceeds of this transaction. So what we were seeing is with multiple offers, some buyers were offering to pay off some of the liens on the seller's property in order to net them a higher amount. So this is now stating the sellers are responsible for their own debt on the property and it can't be paid by the buyer. So we were seeing a lot of that with investors that were taking over properties that sellers were in financial distress. I'll get you out from under this. I'll pay off your second mortgage. I'll pay off the mechanic's lien. I'll pay off this in order to get their offer accepted. So probably won't affect you guys, but I wanted you to be aware that seller is responsible for paying all of that themselves, not the buyer. Another easy change, section 15. So this is just so you guys can monitor. So same page, next section down, section 15, we're in the closing cost, closing fee, and association fee and tax section. I want you guys to be mindful, this is not on your dates and deadline calendar, but the seller's now required at least 14 days prior to closing to request the HOA documents. Because HOAs are taking a little bit longer to get those association documents to the buyer, it's now part of the contract that they have to do it within 14 days of closing. So that's not on the date and deadline chart. So you guys just now have to make a mental note that when you're the listing agent, you have to look at your closing date and back 14 days up and know that that request has to be made by that date. and mark your calendar.
Well, this was a real hot
It's a
set.
status letter though, right? Which is ordered by the title company.
And
The
title companies,
responsibility of the seller, but done by the title.
Sometimes. Well, it was a real problem in some of the classes because it was taken by some to mean that the buyer had to receive that by the 14th day.
because yeah, this is
It just says order.
Request.
the association, well, to deliver to buyer.
Yeah,
Right.
that's
That's
what's
another one of the-
requested. The
yeah.
request is please send these documents to the buyer.
Yes, correct, but they don't have to be received by the buyer on that
Right,
day.
because, yeah, but it was going totally the other direction.
So the purpose of this status letter being requested within 14 days of closing has to do a lot with special assessments. Because
Yeah.
buyers are getting through the contract period and all of a sudden they're getting hammered with a special assessment. Now, title companies will get that status letter and the HOA has to disclose on that status letter if there's a special assessment that's coming down the pike. Obviously, it has to already be voted on and in the works, but that's how most buyers learn about special assessments, or if there's going to be an increase in dues, which we get to the end of the year. Buyers buying right now that are closing in January, there might be a dues increase that they need to be aware of, or if there's working capital that's collected. Oftentimes, a buyer will have to pay into the working capital reserve for the HOA, and when they sell, they get that money back. That's been creating some hiccups with these buyers going, I didn't state anywhere in this contract that I'd be willing to pay $200, $250 in working capital. So getting these requests out early so that the buyer has this information in advance is helpful. You're not sitting at the closing table going, what do we
Yeah.
do?
Well, this made real fights.
Did it?
Yeah, long discussions about that because it was coming across that if the buyer didn't have it in the 14 days, you could cancel the contract and stuff.
Gotcha.
So, but it's like, that didn't make sense. to
Yeah,
me.
I don't read anywhere where the buyer has termination rights, anything like that.
He was
So,
coming from Symmetrical classes, so maybe it seemed like those guys ought to be a little bit more in sync with each other when they're teaching these things. So, you being former president.
I'm like, I think we have it.
So we get some great feedback for you.
Yeah.
We do have a board member at the table.
Yes, we do.
He's texting
I'm
Spencer right now.
listening.
Not just a board member, you're in the education committee.
Yes, I am.
There you go.
So this is very good feedback, actually, for the, I
Yeah.
heard it from Tony and yourself and other people saying, ask your broker, ask your, we can't have instructors. I mean, yes, some of the block is going to get passed on to me, but
A lot
Not
of
that
it's getting
much.
passed on to you guys. Because,
John did not pass anything.
No, there was nothing in here that, when I took it from John Goodman, that said, you should ask your broker. He gave very distinct opinions on, this is how I would do it, this is how you should do it. So that was helpful because now I can tell you guys the same thing. And of course, we talked about it to make sure that we were in alignment with what his, advice
Yeah.
was.
And I took a class with Ron Goldstein. I mean, he told us the same thing. Always ask your broker.
yeah, but it's because they have all these disagreements that it's like the instructor doesn't really have a good enough answer. Your answers for these things are really good, but they've left so much of it to controversy and stuff. I mean, it's incredible. That class, and they were Symmetrical classes.
And I think some of this is open to interpretation. I mean, I'm telling you, when you represent a buyer, check general warranty deed, and maybe they don't feel they have the right to tell you guys that. But we had a nice discussion about the benefits of special warranty, the benefits of general warranty, and how would you want to be represented if you had a realtor working on your behalf?
And we're the ones that back you up. At
Yeah.
Smedra, Steve Olson is not going to back you up. He's at Remax. I mean, you
Yeah.
do something wrong, the last thing he wants to is a phone call from you going, you know what, I suggested this and this is what we got into trouble. And Steve told me. So when there is interpretation or best practices, and that's what a lot of this is, best practices.
Well, and some of this information came from the class he did, and it was Ron Goldstein.
Right.
But yeah, and it was just real arguments on a lot of this stuff.
Were you in the 2-hour class?
And the 3-hour class.
And
Look at that, this is your
She's
third
a-
class.
That's one of all.
So we're gonna call
Sarah will be
We're
teaching
gonna
this
call
next time.
Sharon. So one thing that did come up in my class, which I thought was good, so I want to pass along to you guys, is what happens if you have a cash buyer that wants to close in 7 days? How do you request 14 days prior to closing. You don't. So you have to draft an amend extend that overrides this.
We have to remember
So
this.
you
because
have
it's
to
a
remember
date.
that. And it's
Yeah,
not even
no.
on your
Right, it
deadline
says
sheet.
at least 14 days before.
At least. So if you have a closing that's gonna occur within 7 days, you can't do it at
Doesn't
least
say,
14 days in
Yeah, it
advance.
doesn't say less than.
Minimum of 14 days.
But they got all the way up to 14 days.
I don't
to
know
do it.
why they didn't put it on the date and deadline charge.
And
Because
they
that's
need to
gonna
share
screw
that.
me up, because I won't.
You guys need
Yeah.
to be triggered.
And then the
You need to see
your
it.
transaction coordinator, hopefully they're taking these classes too, right? So they know that that's in the contract.
Not.
Who?
Our transaction coordinators, right?
Well, technically, we're going over this week.
How about the HOAs? Can we get them to take this class? Because I've got an HOA right now that says I will not provide a letter until 3 days before.
Yeah, no kidding, Steve.
You really have to amend this if you get this letter before 14 days, because they want what, quote unquote, the most current. That's what they're saying. That's their reasoning.
Yep.
So this is past all of your objection deadlines for HOA. So if there is $1,000 working capital, your buyers are on the hook because they can't do anything unless it's a loan objection.
Well, I agree.
Because usually your HOA deadline, your HOA association documents deadline is, 10 days
out.
after your contract deadline.
Right.
So if there happened to be something in that status letter, which right now we're not getting it till closing anyway, so,
Yeah.
it's
So
better, but.
Potentially it's like,
I think that's why you have to request it as soon as possible, at the very latest 14 days.
But that's not,
How I'm reading
they're
it,
saying
yeah.
at least 14
Yes.
days prior to closing.
Yeah, no later than 14 days.
So
But
you
I
can
think
get
that-
it sooner.
Oh, you can definitely get it sooner, but I think the question was, what if we close in 7 days? He's got up to 14 days to get it. We haven't said, you need to get this to me before closing. I need it in 3 days. You don't get your 14 because we're
Yeah.
closed by then.
and,
Right.
well, and Angie's
Yes.
made a good point that if something comes up in the status letter that the buyer doesn't agree, like a special assessment, there's your past inspection, your past title, your past HOA, but there is a provision, and I can't find it because there's all these red markings.
I know.
And I can't sift through. There is something in this contract, and I will find it and get it to you guys, that states that upon discovery of something new with HOA documents, the buyer has a minimum, or the,
Buyer or seller.
if the buyer discovers that there's been a change to title or a change to association documents, they have the right to review and
Oh, yes.
terminate. I can't remember what section it is. It's like 5 days prior to closing or on closing, whichever occurs first. But yeah, so that would, I believe, fall under the discovery section, so that if something came up with a status letter and there was new information brought to light, there's that automatic trigger that comes into effect, that the buyer has the right to review and object. And it should be under the title section. I'm just not finding it.
I'll look for it.
Stacy, while we're on the HOA documents, can you go over section 3.2, association documents to buyer? Because there is so much redlined in that section.
So do you mean section, not 3, do you mean?
No, seven, association documents to buyer.
Yes, so I was gonna hit this if, towards the end if we have time, but we're still doing good on time, so let's talk about it. Basically what they did, section 7.3 is what Tony's asking about, it's page 7. You're gonna see a bunch of red line marks at the top of the page. They took out what was currently written in the contract and elaborated on it more down below. So a lot of this was already referenced. There are a couple paragraphs that are new. So let's talk about those. We already had the sellers providing declarations, articles of incorporation, bylaws, operating agreements. So section 7.3.1 is not any different than previously noted. Section 7.3.2 is pretty much the same. They just got a little more wordy with it. You're still going to get meeting minutes, any executive board or manager meeting minutes. 7.3.3 is a new one. The seller is now obligated to provide the association insurance policy. I think that's a good addition. And they elaborate more on that. Section 7.3.4, this is an interesting one. A list by unit type of the association's assessments, including both regular and special assessments as disclosed in the association's last annual disclosure. That was not one that we had in our association packet prior. So hopefully the HOAs are getting memos that they now need to include these
This is gonna
documents
be-
in the
yeah.
packets. But it's gonna be your guys' responsibility when you're on the buyer side of the transaction to go through and make sure you've actually gotten all these things when the title company sends them to you.
And what happens if we don't? I mean, because these are just coming out. If we've got closings January, February, I mean, what are the odds that the HOA management companies has this in there? And if they don't, what do we do?
Well, if you've got a closing coming up in January, there's a high likelihood that you're already gonna be getting your HOA packets this month. And so you're gonna retroactively be under this under our current contract, because you will have drafted it on the current contract, which does not have these changes. Anything January 1st and forward will be on this new contract. So HOAs may not be on board 100% with this. So you're gonna wanna go through the packets when you get the information from the title company. If you're missing anything, you're gonna wanna request those documents. If you don't get those documents, you're gonna wanna amend, extend the deadline.
Okay.
Yep. So there's gonna be some growing pains with this one.
So with the, going back to just with the status letter, is it too soon for the title company to request it when they're requesting this? Because you're not, unless you're closing in 2 weeks or whatever, but.
They usually try to request the status letter as close to closing as possible to make sure it's the most current.
Right.
Because depending on time of month when you request it, the seller's HOA payment for that month might be going in at the same time they're
Right.
getting the status letter, and then the HOA says they haven't paid their December dues. Well, the check's in the mail. So they try and get it as close to closing, but it might not be a bad idea for them to request the initial status letter and request an updated one as they get closer to closing.
Which I'm sure the HOAs will start charging for.
Oh, yeah.
Probably.
Yeah.
$5,000.
Yep.
Probably.
Who's to stop
Yeah.
them? Why wouldn't they?
Yeah.
Because, yeah, if you had to request another one, they're gonna charge you.
Mm-hmm. So that 7.3.4 is a new provision, the list of unit types of the association assessments, or list by unit type of the association assessments.
So
And
it's
then,
just specific to your unit? Because a lot of the times when they send those things out, they kind of show unit whatever to this gets this type of special assessment.
yeah, so the way I'm reading this, a list by unit type of the association assessments. So some associations have a flat fee across the board. So all units are charged $250 a month. Some do it by square footage. So the bigger units pay more, the smaller units pay less. Some do it by location in the community. So it sounds like this is obligating the HOA to provide a list of all the assessments regardless of the unit. So even if your buyer's buying unit A, they're gonna know what unit B, unit C, and unit D pay for assessments.
This is gonna be so difficult to get because it's so difficult to even talk to anybody at an HOA, much less
You know what you're talking
get this specific kind of.
I think that sounds like a problem you have.
I know.
Yeah.
They're so cooperative.
I know.
So it definitely will be challenging. The next paragraph down, 7.3.5, we've always gotten most recent financial documents, operating budgets. They just spell everything out a little more comprehensively so you know exactly what you're supposed to be getting. So in here it does say status letter, record change fee, reserve study. So that paragraph stayed the same, it just got a little bit more wordy. And 7.3.6 is a new one. We now need written notice from the HOA to the seller of a construction defect action within the past 6 months. So that's now going to be a new disclosure.
So once again, this is on the buyer's agent that has to make sure that's in there, but you don't even know. Like,
But you don't even know if it's
If it-
something that
exactly,
should be.
right.
So you're going to have to say, hey, just making sure that there aren't any construction defect
just gotta.
litigation, yeah, that we should, or yeah, construction defect action that we should be aware of.
Do you know, does it help if you suggest to your sellers or whoever, I'm so confused right now on some of this stuff, but to have the title company be the one that sends out all that documentation. Because a lot of times they got it from past transactions and stuff that they've done. Because, or do we have to go back because it's specifically saying we have to give certain things? And we're not going to really know if it applies or not. Do you have to do an amendment to say this list by unit type's not available? I mean, how much are we going to be held to making sure that we've got all this stuff? That's part of the controversy that I've heard, you know, from those meetings and stuff. And they were putting it back on the buyer to be the one to make sure that they get all this stuff.
Yeah, so, I mean, I definitely think when you're on the listing side, it's helpful to have the title company initiate this. Because if you give this subsection or the section to your seller and say, I need all these documents, log into your portal and send them all to me, they're going to go, huh?
I know.
The title company's familiar and used to dealing with this, and a lot of times they have them prepackaged from previous transactions. As far as confirming receipt of them, it will be buyer's agent and buyer, their responsibility to go through and make sure they've gotten everything. If the title company didn't send it all, somebody needs to say, you're missing the list by unit type association assessments. And if you don't have that, if they say we don't provide that, we can't provide that, we don't have access to that information, we refuse to provide that, it might be a good business practice, and I don't know what your opinion is, to draft something that states seller hereby acknowledges that HOA does not have a list of unit type association assessments.
Yeah, I was just curious what kind of liability there was when they're saying that you're going to do it and it's in writing.
I don't think there's liability when it doesn't exist. If the document doesn't exist, you can't provide it. So some HOAs may not have that information compiled. So the seller can't be forced to provide it, and the buyer, you know,
Buyer has the right to object
to
or not
object
object.
or to move forward.
You
with
know,
it.
that's their,
Yeah.
it's their option.
Right, and so you could just leave it at that.
It
So-
seems to me that I'm not gonna just like tell my sellers to go get this
Me neither.
information anymore.
Yeah. Right.
Just
Yeah.
to say it's a
Yeah.
cost.
In the
Uh-huh.
cost,
Yeah,
yeah.
done now.
So
Whatever.
Stacy, in the class that I took,
Association.
they recommended that we send an email once the documents have been sent that says, please confirm receipt of all needed required documents. And then that way, you know, if they didn't get something that they need, that you have that opportunity to get it or respond to it. What do you think?
Yeah, and that's one of my favorite best business practices. And if you go on to Elevate and you look at my seller and buyer email template communication forms that I've put on there, that is one of them. Here's a copy of all the HOA documents. Please confirm receipt and that this meets our association document deadline responsibilities
Yeah.
or obligations. And they respond back, got them all, thank you. So I think that's a great
What
business
does that
practice.
mean?
Yeah.
Or they say, no, we're missing one. I just combed through all of them and we're missing X.
I know you're
And I
lucky
don't
if
know
they
where I heard
even
it
look at
from.
this stuff.
Yeah.
I'm sorry, go ahead.
Well, no, I should say you're lucky a lot of times if they even look at it, you send it to them and you're telling them that it's their responsibility to read it, but do they or not? So
You
again,
never-
getting that email that says that they've accepted what's been received would be really
Kind of
important.
gets us off the hook. But I heard somewhere that title companies are really creating a lot of dialogue with some HOAs that are receptive. And of course, title companies gonna let themselves off the hook, trying to get themselves off the hook too. So they're preparing a document at closing to be signed that says they did not receive certain documents from the HOAs. It's gonna be signed by both parties because they don't want to be held liable to not providing something that cannot be provided. And I don't remember where I heard that from, but
That'd be good if they
they're
do
preparing.
Yeah, that's
they're
actually a
preparing
good-
a
really good.
document.
Yeah.
That's just letting you go, I still don't have, again, the responsibility is back on the seller and the buyer.
Of course.
We help initiate, they help get it, but true responsibility is the seller is to provide this.
Yeah.
All right, because I really want to talk about FERPTA.
Right, gotta do.
Yeah, anybody have any more questions on this or are we good to move on? Okay. All right, so FERPTA, section 15.8, page 14. Foreign Investment Real Property Tax Act. So right now, if the seller is a foreign person and at closing, this is discovered, the title company holds 15% of the sales price for taxes, federal taxes. If the seller won't pay that, or the title company doesn't realize it's a foreign person and doesn't catch it and collect that 15%, the buyer is responsible. So they added in section 15.8.1, which states, and I will read this because I think it's important, the Internal Revenue Service may require a substantial portion of the seller's proceeds be withheld after closing when seller is a foreign person. If required withholding does not occur, the buyer could be held liable for the amount of the seller's tax, interest, and penalties. If the box in this section is checked, and they're adding a box, seller is a foreign person for purposes of U.S. income taxation. If the box is in the section is not checked, seller represents that the seller is not a foreign person for purposes of U.S. income taxation. Seller agrees to cooperate with buyer and closing company to provide any reasonably requested documents. I circled reasonably requested, and we'll come back to that, to verify seller's foreign person status. If withholding is required, seller authorizes closing company to withhold such amounts from the seller's proceeds. I won't read that last sentence because I want to talk to you about this checkbox. So when you write an offer, do you check it or do you not check it? How do you know if
We
the
don't
person
You
know.
would check it, so they'd have to counter it if it isn't right.
So
I don't
debatable.
know.
Some are saying check the box so that the seller's required to counter. What if you write a really, really good offer and another person writes a really good offer and they don't check that box and the seller says, I don't want to have to worry about countering?
Yeah.
You're putting your buyer at jeopardy for a seller creating a
Or they're offended.
or they're
Yeah.
offended, or you're accused of discrimination.
Yeah, I know.
Well, if their name isn't Bob Smith, I'm going to check the box. If it's Bob Smith, I'm not going to check the box because I know Bob's not foreign. So now you're opening yourself up to discrimination. So whatever you do, always do it the same. If you're going to check the box, always check the box. If you're not going to check the box, don't ever check the box. I think it's probably wise not to check the box because you don't know.
Unless you call them, they're like, yes.
Stacy, could you put something in additional provisions that if the seller is, that he will let the buyer know?
I don't see why you couldn't.
Okay.
Are you gonna do that in every single?
Yeah,
offer?
but again, you're
Always
gonna,
right?
Yeah, you'd have to.
You should.
Yeah.
I mean, I think you'd have to do that because if you don't check the box and they end up foreign, then, you're not protecting your buyer.
Right.
So the way they're trying to positively spin this is they want us as agents to be extremely proactive with the title company. And most title companies right now, when they're getting the title commitment order and a copy of the contract, they're sending out the seller affidavit in this FERPTA. They're asking for the seller's tax ID number, and they're sending them the IRS approved FERPTA affidavit to sign in advance. So what they're wanting us real estate agents to do is to be very proactive with the title company and the listing agent to say, hey, has the seller signed the FERPTA affidavit? And so it's now putting something else on your plate because the seller will acknowledge in that affidavit if they are or are not a foreign status. And at that point, then you know how to proceed. The problem with that document is it needs to be notarized. So it's putting more work on the sellers to sign it and have it notarized. Otherwise, they sign it and they bring it to closing to have it notarized. Well, it's a little late at that point for you guys to all determine whether they're a foreign status or not.
Can I have it notarized by the title company beforehand, though,
Mhm.
before closing? Why didn't they revise the listing contract to address it right there when the agent's working with the seller to get determined what the status is?
Great idea.
That's great.
You need to be on that committee.
Well, then you stop and you think about the potential liability.
So they're putting it on the buyer and they're wanting you guys as buyer's agents to follow up with the listing agent, follow up with the title company to initiate that FERPTA affidavit as soon as possible in the transaction. So if a seller is hesitant or unwilling to sign it, you guys know in advance.
Yeah, in my last closing, the title company asked me, how are you guys going to verify FERPTA status? It doesn't sound to me like they are too keen on doing that process either.
Can you put it into due diligence? Can you put it in yours?
It's interesting.
Yeah. There we go.
What was that meant?
Yeah,
Easy to
right.
have in everyone.
So-
due diligence.
So the suggestion was, could you put it in the due diligence document? So under section 10.6.1.2, where you typically say, hey, if you have any surveys, any soils reports, well information, septic information, that's typically where you put those kind of items.
So have that done by the
So
due diligence.
could you have the seller complete a FERPTA form? I don't
Well,
know.
another question,
And of course,
Todd, is it possible, I mean, for example, if you stop and think about this, if title's not willing to address the FERPTA issue on the front end, and there's a penalty to your buyer, would they have liability as a title company for not clearing that requirement as part of title, delivering a home under a condition that the contract stipulates?
That'd be a loophole
I don't
somewhere.
believe so.
Yeah.
I mean, we've been signing FERPTA forever.
Yeah.
The FERPTA part.
If somebody's trying to hold or push this off to a buyer, well, I'll tell you, we have to protect our buyers, because what's the penalty?
It's the government.
Well, it's not to somebody, it's the IRS. I mean, it's
Yeah.
a federal law, so.
Well, it says buyer is held responsible for the taxes. So I
That's the
think
key.
as an agent representing your buyer, you want to make sure that they sign the form.
And
And
that's,
they
that's
agree to sign the form, you know,
with
fairly.
the title company
To
that
make sure
is
that,
proactive, and I know First American does it. I know Land Title does it. I mean, they do it all the time.
But they do it at closing.
No, they
Yeah.
send it out in the early packet.
Yeah, when
first
they
send it
ask,
out.
what are your commission fees? Are there any admin fees? Please have your seller sign this FERPTA affidavit and provide their social security number. It's in that initial introduction email coming.
But
from the
are they
title company.
notarizing it then?
Mm,
They're
no,
not
they're not.
notarizing it till closing.
They're not notarizing it till closing. So the seller signs it and sends
Oh.
it back. They have it in their file,
At
and
least
then
they
they
have it.
notarize it at closing.
that
That's
they
how
have
it's
it.
done right
So they
now.
would know at that point.
Well, they
if they're
tell
going
us
or
us
not.
you
Yeah.
can sign it.
Because they can confirm.
Yeah.
I got a social, I
Yeah.
can now confirm something, now I'll stamp it, but that's still better. I mean, this, they check a box, great, they sign it. They say, I'm not a foreigner, and they show up at closing, and they really are. I mean, this doesn't do the research. This is about as good as sending out a form saying, are you or are you not? I mean, if you're dealing with someone who's a bad person, they're gonna be a bad person.
Yeah.
If you're dealing with someone who's a
They're
good
lying.
person, they're gonna be a good person and tell you up front, and whether you got that stamped or not, you're fine. But
Yeah.
you definitely wanna work with the title company that's sending out the form, being proactive, and getting that information up front.
It's 12 o'clock.
Oh, class is over. Thanks, Steve.
So
So
basically, there's no way to protect our buyers, it's a way to protect ourselves. I mean, is that basically what this paragraph?
I don't think this paragraph changes anything
I don't
about the
think it changes it.
procedure that we've
Yeah.
been under right now. I mean, I think everything's gonna stay about the same. It's just acknowledging that if a seller happens to read their contract, they will see in here that it states, I will cooperate, I will provide reasonable documentation. It's just bringing it to their attention, where before we didn't even have it in here,
Bringing it to your attention.
and bringing it to your attention.
We talk about it once a year in the mandatory update, and other than that, we haven't talked about it.
Yeah, and of course, the controversy is, if you find out they're a foreign person, do you have to amend your contract and say, the box under section 15.8.1 shall now apply? Yes, you do.
Well, I think in one of the classes, it could be the one that you're in too, where they were saying, because there was a guy that was in there that had a green card, and he thought that meant that he would not be subject to the tax. But they kept saying that if you have a green card, you would still be subject to that foreign tax. So, I mean, it's,
Typically, green card means the pay
Do they have a
taxes.
social security then?
but they were, and then somebody said they'd be taxed at a higher rate or something like that. I don't know.
Right, yeah.
But it's like, you really have to have legal advice with that kind of
Right.
stuff.
Sure.
So
About
again,
who is
just
foreign, who isn't. or
putting it on your radar, another thing for you
Yeah.
guys to be aware of.
So Stacy, say we knew that someone, our seller is a foreign person. Should we put it in the broker remarks? I mean, so that people know that that section should be checked or not? How do you feel about that?
In the,
Well, if we know, we just check it.
Well,
No,
if you're a
you're-
listing agent.
As a listing agent,
Right.
if we know that the person is a foreign person, should we put it in broker remarks that section 15.8 should be checked? Would that help or not?
I would.
I don't know how I feel about that.
You feel like it's
Buyer's
discrimination.
agent should,
Well, I don't think it's discrimination.
you know how we say buyer, I'm sorry,
Yeah.
No, go.
you know how we say buyer to verify, blah, 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 in broker remarks?
Mhm.
There's nothing wrong, I don't think, by saying buyer to verify, pardon me, all measurements, HOA and school information, and FERPTA, whatever, however you want to say it, FERPTA section of the contract. Okay, big deal, but even though we put that in there, that doesn't mean they're gonna, doesn't mean they're going to actually abide by that, because what I found is that certain buyer agents don't read the MLS,
Okay. So what I'm saying,
let alone their
is
contract.
that if we know that our person is a foreign person, and someone, we know that a buyer is going to question whether to mark this box or not, if we just put in there to please check box 15.8.
And how can the buyer verify really that the seller is a foreign person other than calling that listing agent?
You
Right.
don't
That's
need
what
to-
I'm saying. As
So
a
yeah,
listing-
you don't need to verify
I mean,
it.
if somebody
So
says, I'm a foreign person, please withhold my taxes,
Right.
why would you need it? Well, sure, if you want me to.
Yeah, you don't need to go the extra
That's
length.
great.
yeah.
So,
So I think. Go ahead.
please. I hate putting stuff in the MLS that tells people what to do and what not to do, because you only have so much room in the broker remarks, and it just.
Okay.
It's easy enough as a listing agent for when you get an offer for you to do an amend extend that says 12.8 to be checked, seller is a foreign person. And we'll,
Okay.
When you find that out.
when you, well, you are the listing agent.
So you're
So,
a
you
yeah,
get your
I didn't hear
offer,
what-
comes in,
Gotcha.
you do an amend extend, you don't have to carry a counter, that scares people, you amend extend, and just state that you're looking for with a foreign person, and that we will fill out the for it and have monies with help. I mean, you
Because
can
the
easily do
only
that.
thing that I was worried about, Tony, and I'm just thinking way outside the box, is I don't want there to be a reason for a buyer or a buyer's agent to discriminate on the property. Oh, this is going to be more challenging because we're dealing with a foreign person. Oh, I don't want to work with a foreign person.
Right.
Oh, my clients don't want to live in a house that's owned by.
Right.
So I think you're just opening a door that we don't want to open.
Right.
Okay.
Take that in MLS.
Because your seller may say that caused us not to get as many
Exactly.
showings or as many
Uh-huh.
offers.
Sure,
Right.
yeah.
Yeah.
Okay.
Do an amend extend and state it when you get your offer.
I have, interestingly enough, a listing coming
Talk
up.
nice and loud so they can hear you.
Okay, so I have a listing coming up. The seller, so the property is still under the husband and wife, but they've since been divorced. Wife got possession, or, got the property, so the husband's not supposed to have anything to do with it. She never went to do a quick clean and nobody told her. So his name is still on. He now lives in Brazil, where he's a citizen over there. So it's been a little bit crazy. We're working with her divorce attorney from 15 years ago
Oh my gosh.
to see how we can get his name out so she doesn't have to pay for it.
Wow.
Should they close it?
That's a lot of,
We're not listening yet.
Not listening.
We're,
Gotta be proactive and.
yeah.
oh yeah.
Good.
We're
That's a good idea.
clearing the attorney.
All right, I know we're in our maximum amount of time. I want to just bring to your attention one other section, and then we will head out.
Stacey, can I mention one thing and make sure that you agree with this? the class that I took, the guy said that if the property is below 300,000, you don't have to worry about this?
You are correct.
Okay.
So one other thing I wanted to point out, and I think this will help with a lot of confusion, page 17, section 31.1. The following documents are part of the contract, rather than the following attachments are part of the contract. In section 31.2, the following documents have been provided, but are not part of the contract. I think a lot of times you guys were getting confused on whether a document should be attached or just provided. So for example, section 31.1, the following documents that are part of the contract would be lead-based paint, would be source of water, would be personal property addendum if you have to use it. Things that would be provided, lender letter, copy of earnest money check, seller's property disclosure, square footage disclosure. So think of it as items that are negotiated in the contract, personal property agreement, lead-based paint is subject to buyer doing risk analysis and all that. Attachments are just supplementals. Because a lot of times I get questions from you guys. How do I know if it's attached or not attached or part of the contract or not part of the contract? So now it specifies documents have been provided.
Where are you looking?
31.2. The following documents have been provided,
See, it was
but are not part of the contract. I think that cleaned up some wording a little bit, which is helpful.
So what a property disclosure that has a source of water disclosure in it.
Seller's property
Been provided.
disclosure is not a state required form,
But the
but the water disclosure is.
And if you don't have a separate water disclosure and you have it in your SPP instead,
But you're not going to know that when you write the offer.
But when you
But
write
you're-
the offer, you're
you're
probably
not-
not gonna have the source of water
you're not
anyway,
gonna be
because you don't
sending
get
it.
that till after.
but
Yeah.
that should be part of the contract.
But do you write all that even though, because it says documents have been provided?
Yeah.
Because you're not providing it when you're writing the offer necessarily because you don't have it to sign.
Well, this just says the following are a part now.
And isn't it beneficial if you
Bottom
want the document included and name them?
Say it again?
Wouldn't it be beneficial to the contract to make sure, if you're representing your client, that you want specific documents? For example, you may write an offer that you want a seller's property disclosure because you have suspicion they don't want to provide it. Would that be, well, obviously that may get you kicked out of consideration, but if it's critical to your buyer, if they ask for that, wouldn't you want to list all that in there anyway?
Well, I think in this section 31.2, it's documents that are being provided at the time the contract is executed. So if you're attaching a lender letter, if you've already gotten all this disclosure forms and the closing instructions, sure, write it in. But if you don't have that stuff yet, then I don't think you need to put it in there because it hasn't been provided yet. That's why you have a lead-based paint or a seller's property disclosure deadline, so you can get that item.
Would you list those in 31.1 then, obviously?
Not all disclosure forms are part of the contract, though.
No, but if your buyer wants a property disclosure and the seller is saying, I don't want to fill one out.
Well, it already has its own section.
Yeah, seller's property disclosure already has its own section, so you don't have to worry about that.
That's true. Okay. I'm just trying to think in terms of representation.
Yeah.
Anyway, fair enough.
What I'm hearing is, there's probably not much of anything that's going to be in 31.1 because you're probably not going to have it at the time of writing the contract to buy. Is that right?
So the
Unless you
language
have
between those two sections are different. So the language in 31.1 is the following documents are part of the contract. It doesn't state they've been provided, but they're part of the contract. So lead-based paint has to be a part of your contract.
Okay.
Does that make sense? So that would definitely apply in that section.
Okay, so you would write in lead-based paint, the water addendum, personal property agreement, anything else?
Those are the only three that I can think of
Okay.
that have to be a part of the contract.
And then the post occupancy is right below that.
Yeah,
so
post
we're good there.
occupancy is addressed in its own section, so you don't have to put that in.
So am I confused then, thinking that come 2019, I'm writing an offer for my buyer, and I don't have a lead-based paint disclosure?
Because it's not built prior to 1978.
Well, I don't, well, I'm writing this offer for my buyer.
They haven't given it to you.
Yeah, and I haven't received one yet. That's why we have a termination date, lead-based paint disclosure termination date.
Exactly.
So you can actually get an offer written.
So I'm gonna write the offer, but I don't have to worry about it being a part of the contract.
No, that's part of the
It's
contract.
part of the
It's still
contract
part of
because
it.
it's, yeah,
It
it's
doesn't
still,
say you've
it
received
doesn't
it
say
yet.
that you have to receive it.
So I really should be putting that in here?
You should be putting lead-based paint in there as part of the contract.
And with 2018's contracts, I wasn't doing that, but I was still getting the lead-based paint disclosure from the listing.
Right. So best practice moving forward.
Moving forward, from here on out.
I think best practice moving forward should be to learn how to use this and communicate really well with the other agent, whether they like that or not. Okay?
That would be very good.
You can't make them pick up the phone though.
I know, that's why I keep calling and texting.
All right, everybody online, thank you so much for joining us. I know it was baptism by fire, drinking from a water hose. So,
Okay, Mark.
hi,
Well, you
Mark.
did really well.
Ah, the man behind the curtain. All right, guys, if you have any questions, which I know you will as this starts to roll out, don't start using these forms until January 1st. And yeah, let me know as you have questions and you're writing them up. You guys, thank you.
So they won't be on CTME. Are they already on there?
They will be on CTM. They're not